My name's Jim McGowan, and you are watching a program sponsored by the Central Bucks Senior Task Force. We meet the first Monday every month at the Central Bucks Senior Activity Center. At 1 o'clock in the afternoon, you are encouraged to attend. If you can't, at least you have this venue to be able to check out what we do here. The only months we don't meet are June, July, and August when we take a little break. The format of the show is interview format. My guest today is Eric Hopkins. He's a principal at the Hopkins & Hopkins Legal Services in Doylestown. His specialty is senior law, and that's why we've asked him to come today. So please help me welcome Eric.
Thank you, Jim. It's a pleasure.
Thanks for showing up on short notice, too. But that's another story. We won't go into detail here. Some of the questions I've proposed here that I have here for Eric are, some are based upon my own experience. I, at various times in my life, had to deal with my mother's estate, and then another time I had to deal with my sister's estate. So I have some idea of what you need to go through when you're talking about wills and inheritances, but that's from a layman's vantage point, which I could probably talk for 5 minutes on that, but I think Eric will be able to enlighten us a bit more on this. So my first question to you, Eric, is what are the top 3 considerations for drafting a will?
Well, if we were to distill it down to that, I guess we would be looking at who your beneficiaries would be, number 1, and number 2 might be who your executor, your personal representative is going to be. And number 3, what are the tax ramifications if you have a will, don't have a will, and so I guess those would be the 3 considerations.
How many people seem to need to be involved? You mentioned tax considerations. You take care of lawyer, legal things. Should another person be brought into the equation?
Well, generally, if people are working with a financial advisor or an accountant, CPA, I think the best approach is always a team approach to what we're doing, so we're not surprising anybody. And but if somebody is not happening to work with a financial advisor, estate planning attorneys are very well equipped to deal with the taxes that come into play when people pass away. Those taxes being the Pennsylvania inheritance tax and the federal estate tax, and oftentimes estate planning attorneys are perhaps even more skilled in those areas than sometimes even CPAs.
Okay, great. When I had got involved with doing the wills for my mother, not for my sister, she didn't have a will because that was she died suddenly. There were different words that got thrown at me, okay, and words that I never heard about until I got involved in something like this. And some of those words were testate, intestate, administrator, executor, executrix, etc. Why all the words? Tell me in layman's terms what those words mean.
Well, I guess it's so we can charge you more money to use fancy words.
Thank you for your honesty, sir.
But anyway, those words actually have legal meanings, obviously. If you die testate, it means that you have died with a will. If you die intestate, it means you have died without a will. And then the law of Pennsylvania steps in to supposedly determine what you would have wanted. The word executor is that is the person who is in charge of your estate. And of course, we like to give feminine and masculine versions of legal words. So that would be executor is the umbrella word, let's say, but executrix would be the female version of that. But we use the word executor all the time. Administrator, administratrix, those 4 words, executor, executrix, administrator, administratrix, they're all the same thing. It is the person it is your personal representative, the person who is administering your estate. And you are an executor or an executrix if you're somebody named in the document, and you are an administrator or administratrix if the person either did not have a will or if we needed to go outside of the will to find somebody to be the personal representative. And the personal representative, the job is the same for all those different titles. The job is to determine what the assets are, what the debts are. The executor, administrator, goes about collecting assets, liquidating assets, paying bills, paying taxes, meeting with the lawyer, the accountant, the financial advisor, what have you. So.
Okay. So those terms are for people with wills? Now, what if you don't have a will? I think you used the word intestate.
Intestate.
For not having a will? Okay.
If you don't have a will, then you are considered to have passed away intestate. And we have a law of intestate succession in Pennsylvania, as does every state. But each of the states are different. We have 50 different sets of laws, obviously. And what that means is that the legislature has decided who they believe you would have wanted to be your heir, who they believe you would have wanted to be your administrator or personal representative. And so that law comes to the forefront, and it may or may not coincide with what that person would have wanted. And oftentimes I find that it doesn't coincide with what that deceased person wanted. One of the interesting things with the law of intestate succession is that in my practice, I find that spouses regularly want their spouse to get 100% of their assets and then their children, but the law of intestate succession does not do that. Essentially, if you pass away, your spouse and your children may end up partners in some assets that you have. And so, therefore, you should always be in charge of your affairs. You should have a will. So it's your wishes and not the legislature's wishes as to what happens when you pass away.
Okay. At what point in your life do you start thinking about doing a will and preparing for that? When my sister died, she was like, I think 48. And of course, no one's going to die at 48 or 49, but it does happen. But what do you find in your practice? How soon do people start doing this?
Well, oftentimes what triggers a will for most families is the birth of children, and because wills can also address guardianships. Who's going to be in charge of your kids if you pass away? However, that said, anybody over the age of 18 can have a will and should have a will. Something can happen to you at any age. Tragically, things happen to younger people, your 40-some-odd-year-old sister. And something will ultimately happen to all of us. We all will pass away. So it is always a good idea to be prepared and have it be your will, not somebody else's will, as to what happens. So therefore, you should always plan to have a will and some other estate planning documents as well.
Gotcha. Okay. You had mentioned if you die intestate, that the state kind of appoints the person based upon the laws of the state, or the Commonwealth in this case. What if that person doesn't want to do it? Like, what happens then if, let's say, what happens if that person doesn't want to do it?
Just like if you have a will and you've named an executor, that person doesn't have to do the job. And the same thing with the law. When the law steps in and says, somebody did not have a will, therefore they need a personal representative, and the law may say, the person who's given a priority for that position is the person who's going to get the residue, the bulk of the estate, let's say. That person doesn't have to do that job. We can't foist that on them. What they can do is they can sign a renunciation, which is merely a paper that gets filed with the Register of Wills that indicates that while they're not giving up their inheritance, they are not able or capable, or they don't desire to be the personal representative. And then what happens is they could appoint somebody, or perhaps the will have a successor. It should have a successor personal representative if the person has a will, and that person can come forward and serve in that capacity.
Okay. And if one should die without a will, and that's called intestate, as we're learning our words here today, who gets what?
Okay. Well, that law would seem to be a little bit out of fashion according to the way we live our lives today. As I mentioned, most people in my practice, if it's a family, the spouse leaves something to a spouse, and then only upon the death of the second spouse do the children inherit. But under the law of intestate succession, what can happen is if you pass away, your spouse could end up in partnership with your parents if you have no children, or your spouse, once again, could end up in partnership with your children in a particular asset. And that seems to be contrary to the way people do their estate planning today. And that law is an older law. Perhaps it could use some modernization. So you can have somewhat odd results if you don't plan accordingly.
Okay.
And also, if you leave things, if it involves children, now you've involved the legal system even further, because when you have children who inherit things, individuals under the age of 18 years of old, they may need a court-appointed guardian to watch over those funds. And the law of Pennsylvania essentially says that a parent, the surviving parent, cannot be the sole guardian of their own child's funds. And so now all of a sudden you're in a legal proceeding and you're involving other people in your family. So it's always best to plan, no matter what you're doing. Plan ahead.
Yes, that sounds good. And if the person dies intestate and the state appoints someone, and that person has control over saying, okay, Johnny, you're going to get the hutch. Okay, Mary, you're going to get, would that person have sole power over everything then?
They do, in a sense, have sole power over the estate. However, they also have a fiduciary duty to deal with everybody fairly, honestly, openly. And so it's not, they really have to step into the shoes of the deceased and fulfill the wishes of that person. But they do have quite a great deal of power, and hopefully when you name somebody, you're naming somebody who is able to get along, and perhaps is the diplomat in the family or whatever, who's going to be able to deal with everybody in a stressful time after somebody's passed away.
Okay. Are all debts required to be paid prior to any beneficiary getting anything from the estate?
The simple answer to that is yes.
Okay.
What happens is once again, the law of Pennsylvania steps in, and it says that the debts have to be paid, and it even prioritizes who has to be paid first. And there are a series of classes of creditors that are to be paid. And
Like taxes, would that be like number one?
well, believe it or not, the expenses related to your final illness, administration expenses, might come even before the taxes. And but ultimately, then it funnels down to your credit cards, and then oftentimes people have an insolvent estate. Credit card companies are unsecured creditors; they don't get anything. And then, of course, the final category would be the heirs, and if there's nothing left, then after paying the bills, they unfortunately would get nothing. So, but yes, bills do have to be paid first.
Okay, I have a specific question for you. If someone has a life insurance policy when they die, but they have no other assets, and there is a specific person mentioned as the beneficiary of that life insurance policy, does that person still have to pay all the credit card debt and things like that?
Technically, that is not a probate asset. It is not an asset within the estate of the deceased person. So technically, it is not the source of payment of those obligations of the deceased person. And that is true if you name a beneficiary of a retirement account, life insurance, annuity, what have you. And also with joint property, where what happens with joint property is the surviving co-owner immediately becomes the owner in many cases of that property upon your death. And they technically do not have to use those assets to pay the obligations of the deceased. Now, there's one very obvious exception to that, which is the Pennsylvania inheritance tax. The primary source of payment of the Pennsylvania inheritance tax, well, first off, we'd look to see what does the will say. Our wills often say that the estate pays it. And a secondary source of the payment of the Pennsylvania inheritance tax, if there aren't funds in the estate or if it's not addressed, is going to be the transferee, the person who received the asset. So some assets, not life insurance, because life insurance is always exempt from the Pennsylvania inheritance tax. Okay. But if it were a retirement account, the transferee, the beneficiary, could end up having to pay the inheritance tax out of those funds, even though technically it is perhaps an obligation of the estate.
Okay. Then if somebody, for example, let's say in real estate, I know when a spouse dies, the other spouse automatically inherits that, right? Tenants by the entireties.
Well, most spouses own their property jointly, and when property is owned jointly by spouses, it is considered under Pennsylvania law to be owned as a tenancy by the entireties. And what that means is then the minute one spouse dies, the other person instantly owns the asset. They don't need any fancy paperwork from the court, the legal system. Really, all they need is a death certificate. So technically, they could go into a bank if there were a joint bank account with a death certificate. They could then put the account into their own name. And if you're talking real estate, that deed could technically stay with both names on it until the surviving spouse decided to sell the property. And then at that point, there would be a recital within the deed that explains why only one person is conveying the property, not both people.
For let's say the remaining spouse, could they put one of their children on the deed after their husband, wife dies? And then at the time of their death, would that property now be outside of probate and outside of inheritance tax purposes?
What happens when you add somebody's name to that account? For inheritance tax purposes, it is considered to be only owned by, let's say if there's the parent and one child, half of it is considered to be owned by the parent. So when they pass away, only half of it is subject to the tax. So if you're talking about a 4.5% tax rate, you in effect have reduced the tax rate down to 2.25%. All right. Now, so that's one issue. Another issue, though, is that there may be adverse income tax reasons to do that. So, for example, if you gift the property to your child, they may not get the step up in basis that they would get if they inherit the property. So when a child inherits the property, let's say the parent paid $50,000, it's now worth $100,000, or what happens if the child inherits the property through a will or intestate succession, their basis in the property is not the 50 the parent paid, but 100. The child sells the property for 100, their basis is 100, no income taxes are due on the property. So you have to be careful when gifting, and that's essentially what you're doing by adding somebody's name, because you can have other ramifications. And the other thing is that that will not necessarily help you with Medicaid planning. If you're doing that for Medicaid planning purposes, and mom or dad continues to live in the house, and the child whose name went on to the deed, if in reality they contributed nothing, that's not going to help you get over the Medicaid issue of that's going to, in other words, that house is going to be an available asset in determining whether you're eligible for long-term care through the Medicaid program.
I see. So if let's say the son or the daughter the parent would transfer the entire property over to them at that point. So the parent's off the deed. Is that better than the parent saying, okay, I'm giving my child the durable, what I think it's called durable power of attorney to sell real estate? Because with dementia growing in the society that we're in and all of us living longer, you know, I have a feeling that this is going to come into play more like, what do you do with your property?
Right.
Before that happens.
Right. So if you are concerned about that issue, really what we're talking about is Medicaid eligibility, Medicaid being the state and federal program that funds long-term care for certain eligible people. And what happens is that there is a 5-year look back, and there's a lot of regulations for qualifying for it, but one of the regulations is you cannot have divested yourself within the preceding 5 years of assets, or you will be deemed ineligible for a certain time period. And so what happens is people are looking at that, getting their name off of assets, putting them into their children's assets, but you have to be careful with that, also with the Pennsylvania inheritance tax, because in order for there to be a completed gift, there has to be intent, delivery, and acceptance. And so, for example, it might be considered, if mom still lives in the house, still has the use to it, it might be, the fact that it's been redeeded might be disregarded by the Department of Revenue for inheritance tax purposes, as well as by the state of Pennsylvania for Medicaid planning purposes, because mom continued to live in the house. So you have to plan carefully. You might plan to have mom enter into a lease of the property where rent is paid. You might have a caregiver agreement where rent money is being paid or value is being paid to you to help get over some of those hurdles. But it's never, in the whole area of estate planning, oftentimes there's no one solution. like everything in life, sometimes it depends on what your motivation is and what your goal is. Sometimes the best course of action is a particular course for tax planning, but it might be different for Medicaid planning, or it might be different for other kinds of planning. So you have to really sit down and look at what is your objective. And it's different. Everybody is different. Each family is.
Okay. I think you answered this question already, but I was thinking, besides like real estate and a house, because that's usually someone's biggest asset, but perhaps there's a $50,000 piece of art or that they own, okay? Does it make sense to say, okay, Jane, I'm going to give this to you, so it's now yours? Okay, so that doesn't show up in probate. Would that?
Well,
I'm a schemer, so,
Yes.
I'll put it this way. I'm not
right,
looking
right.
to, what's the terminology? I'm not looking
You're looking to avoid-
evade, right?
You're looking to avoid, not evade.
That's right, that's
You
right.
Avoid the law, not evade the law. Well,
That's correct.
there's a couple of issues there. In order for there to be a completed gift, once again, there has to be intent, delivery, and acceptance. And if that $50,000 Redfield painting, probably more like a $200,000 Redfield painting, is still hanging on mom's wall, well, she intended to make the gift, but she technically, and anybody would have accepted the gift, but she technically never delivered it because it's still hanging on the wall. So if you were strictly analyzing this, the Department of Revenue would probably take the position that it is still subject to the inheritance tax because there was no delivery of that particular asset.
Okay, okay. You have to ask these questions to know.
Right. Well, you want to do whatever you can to avoid tax, but not evade it. And then I want to also address the probate issue, which is probate is that process of filing the will in a government office, the Register of Wills in each one of the counties, and pursuant to that process, somebody is appointed. Now, and there's been a lot of talk about avoiding probate. And the thing I always tell clients who come in and talk to me about avoiding probate is that, well, you have to bear in mind, we have 50 different probate laws. The laws pertaining to wills, powers of attorney, living wills, probate, they're all state laws. They are not federal laws. The only real federal law that comes into play is the federal estate tax, which most 99.9% of America is no longer subject to. So when somebody comes in and we sit down and talk about what their objectives are, they'll say they want to avoid probate because they heard Susie Orman speak. Susie Orman is wonderful, but I doubt Susie Orman owns anything in Pennsylvania. And so, and if you're reading the Inquirer and it's quoting a Cherry Hill attorney, well, the Cherry Hill attorney hopefully is talking about Pennsylvania law, or if you're reading Money or Kiplinger's or one of those magazines, I hope they're spouting Pennsylvania law, because if not, it's not really relevant. And for example, the probate process in Pennsylvania is very efficient. Technically, somebody could pass away today. If you could get their death certificate, the executor could go right into the courthouse the very same day somebody has passed away with that death certificate, with the will, and they do not need an appointment. It is not a legal proceeding before a judge. It's, you go to the Register of Wills and walk up to the desk, and you would file all the paperwork, you would pay the fee, and we don't have a tax, we have a fee, and you would be sworn in on the spot if you were the executor, and you would walk out of that office with the short certificates, the papers with the raised seal, indicating that you were the appointed executor. That very same day, you could walk across the street to, let's say, BB&T happens to be across the street from the courthouse. You walk across to BB&T, you could open up an estate account, you could ask the BB&T personnel to sweep the savings checking into that account. They might give you temporary checks, or if you wanted, they would write you out a check for whomever you're trying to pay, the funeral home or whatever. So the process is different in every state. And I know that Pennsylvania's, I don't know if it's by plan or just happenstance, it happens to work fairly efficiently. In some states, I know I have clients who have families on Long Island, and the parents have passed away, and it's taken quite a while to get somebody appointed as an executor or administrator of an estate. But that is not generally the case in Pennsylvania, unless you have a dispute or between heirs or something like that. Somebody has filed something in the Register of Wills to keep you from being appointed.
Okay, yeah, that was my experience when I guess I was the administrator or executor of my mother's will, one of those. And when we did go up there, and it was my brother also, myself and my brother, and when we went to the courthouse, that process was like that. I mean, it was very smooth, and I thought it was going to be, you're going to sit there for a few hours and be told to come back in the morning, and then they'll have the paperwork, and then you have to go here and there, but it was very smooth.
And our new Register of Wills, Don Petrilli, he actually has done quite a bit to modernize that office. You now can access records online, some records online. You can use a credit card in there. It used to be you had to pay by check. So it's becoming more and more user-friendly, I'd have to say. The Register of Wills and the process has been fairly user-friendly.
Yeah, we did have Don here. We interviewed him, a few months back. And everyone said, yeah, bring him back again because he had so much to offer.
Sure.
He only told us a little bit of what he had to tell us. Okay, so far we've talked pretty much about wills, but that's the first step, I guess. And that's the first step of putting together something that is going to take care of you as time goes on. What, besides the will, I know there's seem to be about 4 or 5 different documents that people should have lined up.
Right. Well, everyone should have a will.
Okay, so that's what I
Everyone
want.
should have a durable general power of attorney. And everyone should have a living will, at least. They should have at least those 3 documents. Sometimes it can be more than that because, for example, the power of attorney. The power of attorney is a document where you, the principal, authorize somebody to be your agent. And if it's a general power of attorney, you're authorizing that person to be your agent over your life in general. In other words, they can act to cover financial matters, medical matters, personal matters, whatever. Sometimes people break that job into 2 pieces. And so you might have different agents for medical as opposed to financial. So now you're up to 4 documents, okay? And but generally your estate plan consists of your will, your power of attorney, and your living will. And these documents do not expire by time. The legislature periodically does update those different areas of the law, but not often. Last year, we had a new power of attorney law, but it was the first time in 15 years that the legislature had done anything very significant with the power of attorney law. And the law of wills essentially never changes. It's fairly static. And the living will legislation changed in 2007, and we changed some terminologies, and there were some other changes at that point. So theoretically, once you get your documents done, they should last you quite some time.
Okay. I think, one last question here before we wrap up. When you say the durable power of attorney, I've had experience where someone would have something like that and they'd be selling their parents' house, but the title company would say, well, that's not good enough. We want something that for real estate specifically.
Okay.
And I know a lot of people under the assumption you have a power of attorney, you think it's good for everything, but it's not necessarily so, correct?
Right. Well, what happens in our office, we try to anticipate and we somewhat react to problems people have with powers of attorney. And one of the issues we had seen historically was that with mortgage companies and title companies and lenders, there was a little bit of pushback or reluctance to use powers of attorney because they wanted more specific language. So instead of fighting them on that, we gave them more specific language. So if you look at the power of attorney we use in our firm, it is about a half a page long. The section dealing just with real estate is a half a page long, and we put the address of any property that people own in that paragraph, and we identify it by tax parcel so that there's no pushback from the title companies. And the other thing that helps here is that with the new power of attorney legislation, the legislature reinforced the idea that if companies refuse to routinely honor powers of attorney, they can actually be sued and they can for damages because it is a legal document that technically, unless they have a good reason not to honor it, they need to be recognizing the power of attorney. Just as they couldn't say, well, we're going to refuse to recognize your deed. Well, that would be absurd. And so what's happened is hopefully with the new legislation with powers of attorney, we'll have less pushback. And I think we have seen less pushback using powers of attorney.
Okay, so anyone out there that does have a durable power of attorney right now should consider revising it to include specifically any real estate that they own.
Right, and just enhance the powers.
Okay. Okay, well, that about wraps it up for this edition of our interviewing that we do for the Central Bucks Senior Task Force. You'll be able to, by the time you see this interview, it'll probably be about a month from now. But if you tune in 10 o'clock in the morning, 10 o'clock at night on FiOS 21, thank you, Ed, okay, or Comcast channel 22. No, 21? Okay. Comcast. 31. Okay. Thank you, audience participation here. For Comcast, just in Doylestown Township, you'll be able to see it. So, again, thanks for watching, and we hope to see you come around sometime to actually witness one of these interviews. So long.
Thank you.